2.15, policy in the branches of government. So sometimes there are a few competing interests. So Congress and the final say. So we have committee clearance, which is this thing where some congressional committees have the authority to review and approve agencies' actions in advance. So prior to the agencies doing something, this congressional committee will approve it and be like, yeah, you can do that. So then they're like, good to go. They got the green light. Then the legislative veto, this was established by Congress to control executive agencies, and it requires that for certain decisions, you have to wait for a defined period, so either like 30 or 90 days. But in INS v. Chadha, the Supreme Court ruled this legislative veto unconstitutional. Basically, Jagdish Chadha was, sorry, that pronunciation I'm sure is horrible, but he was applying for permanent residency in the United States, but the House ended up rejecting it through a legislative veto when the Immigration and Naturalization Service, INS, approved his application. House rejected that. So Chadha sued, and Supreme Court ended up siding with him and against Congress' use of the legislative veto. Some other congressional acts and the bureaucracy. Freedom of Information Act, so the public right to request access to records or information. Basically, people have freedom to information. The Sunshine Act requires federal agencies to hold their meetings in a publicly accessible place. So think, out where the sun shines, out in public, that's where they have to hold their meeting. And the Whistleblower Protection Act protects federal workers who report or disclose evidence of illegal or improper government action. So basically, if you blow like the whistle on the government action, the federal workers who are reporting that are protected. Competition in the executive branch. So different beliefs and approaches of executive departments make it hard to decide the United States position or decision sometimes. Like you have all these conflicting decisions. Sometimes law enforcement agencies will cooperate to find criminals, but they also kind of want to protect and do their own specific thing. Like they want to keep their agency, like their own single agency kind of. And sometimes upper level bureaucrats get caught between like their boss and the people working for them and trying to balance those two things. And sometimes people will see corruption, but they don't want to say. So therefore, Whistleblower Protection Act, that basically says that they cannot get attacked or anything if they speak out about this corruption. Bureaucracy agencies, they interact with the court. So the U.S. Supreme Court has shaped how Congress can interact with the agencies. Courts get involved when citizens challenge federal bureaucratic decisions, so it checks lawlessness. So if somebody sues a federal bureaucratic decision or whatever, right, that gets the courts involved. Most judicial hearings are looking for a complicated interpretation of a law, and the application or constitutionality are usually concerns, though, for an appeals court. There's an example of how it is dealt with the Justin Timberlake, Janet Jackson 2004 Super Bowl halftime show. Page 242 if you're looking for a little more background knowledge, understanding, but that's not very important at all. More so how the U.S. Circuit Court of Appeals really gets invested in these federal agencies. So like I said, Court of Appeals usually handles that stuff, and unless it's blatantly unlawful or an abusive action, usually the court just sides with the agency. And they tend to focus more on the whole decision-making procedures rather than the actual substance of the decision in these court cases. Now, the appeals court is more likely to uphold the independent commission decisions actually than general executive branch department and agency decisions, so that's a little note for you. Congress gives power to these entities that it creates, but perhaps sometimes they fail to define exactly what these agencies can do. Chevron v. National Resources Defense Council, it goes on for a little bit about this, so I'm going to talk about it. Not a required court case, but might be a little more relevant in this chapter. So basically, it pitted Chevron Oil against the Environmental Protection Group. EPA passed a regulation that it grouped these oil plants or power plants. It grouped these plants into this very geographic area for pollution and pollution measurement, a little bubble. Basically, this created this possibility that certain plants wouldn't need this permit if it wouldn't affect their impact on the bubble or whatever. The permit would be required by the Clean Air Act, but with this little loophole, they wouldn't necessarily need it depending on the situation. So then the NRDC challenged this to protect the air. The appeals court set aside the EPA regulation, and Chevron appealed So the Supreme Court overruled and established the Chevron doctrine, under which courts defer to agencies when laws defining responsibilities are vague or ambiguous. So basically, under the Chevron defense, agencies can not only determine what the law is, but also change its interpretation at any time. It's kind of confusing, but if you understand that last little bit, agencies can not only determine what the law is, but also change interpretation at any time, you should be okay. Or at least I would think, and I would hope. But that's page 243 if you want to take a closer look at it. Again, not a required court case, neither is the one about Justin Timberlake and Janet Jackson with like the FCC. Anyway, thank you for watching. I hope this helped. Go check out my YouTube, go check out my other videos. Like, comment, follow, subscribe wherever you're watching this. Tell a friend.